All right, this is the Monday, March 26, 2012, work session of the River Edge Mayor and Council. It's about 7 p.m., about 12 hours off. If we could stand for just a moment of silent prayer or reflection. If we could have our acting Borough Attorney, Mr. Raimundo, lead us in a salute to the flag. I
pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All right, the New Jersey Open Public Meetings Law was enacted to ensure the right of the public to have advance notice of and attend any meetings of public bodies at which any business affecting their interest is discussed or acted upon. In accordance with the Act, the Mayor and Council of River Edge have caused notice of the meeting to be published by having the date, time, and place thereof posted in the Borough Hall, and notices have been sent to the Bergen Record and the Ridgewood News. The mission of the governing body is to provide essential services through the establishment and implementation of public policy to safeguard our infrastructure, providing honest, courteous, and professional services, and establish a sense of trust and accomplishment with our residents. Through research and prudent planning, we seek to minimize our risks. In fact, we have a risk manager here, and improve our services. We are sensitive to the needs of our taxpayers, while realizing that the governing body cannot be all things to all people within the revenue constraints imposed by state mandates, economic conditions, and prevailing attitudes about taxation. Can I have a roll call, Denise?
Councilwoman Murphy?
Here.
Councilman Court?
Here.
Councilman Porco?
Here.
Councilman Ignone?
Here.
Councilman Bartoloni?
Here.
Councilman Papaleo?
Here.
And Mayor Mascarotola?
Here. All right, we'll take the agenda out of order because we have Mr. Grubb here from the MELGIF, and we're going to have a mandatory employer practice liability training. So, Mr. Grubb?
Yeah, thank you. Thank you very much, Mr. Mayor. What we call property casualty insurance costs the local units of government in the state approximately $400 million per year, or approximately $50 per capita. That's a very rough average. Each individual town is going to be somewhat different depending upon the nature of its operations and its rateable base relative to its population, whether it's a career or volunteer fire department, a lot of other factors. But the $50 average statewide is pretty good. As you see, half of it is workers' compensation, 40% is liability. We're going to be focusing today on a portion of liability called public officials and employment practices liability. It's not going to be very much a surprise to everyone that this is an area that has become a major concern, primarily because of the fact that we have a court system that is very plaintiff-oriented. In fact, of all of the states, we're rated as the most plaintiff-oriented. One would just simply have to read the articles and the records every week to understand what's going on around the state and here in Hackensack. And in particular, employment practices liability is just absolutely mushroom. This takes a look at the cost that is covered by insurance. Keep in mind, as we'll see later, about half the cost of these claims are not covered by insurance, but just the part that is gone from $41 per full-time employee equivalent in the year 2000 to almost $500 per full-time employee equivalent 10 years later. In other words, it's increased by a factor of 11. And again, one would just simply have to read the records periodically to understand what's going on. What is employment? What is public officials and employment practices coverage? We refer to this as a gap policy. In other words, it covers things that are not covered by regular policies. And in particular, regular liability policies do not cover claims arising from wrongful acts by public officials and employees. Those are excluded in the regular liability policies, hence the reason for the development of this specialized coverage. And so the first of these policies were issued, maybe 25 years ago, maybe 30 years ago. And at that point, the cost was negligible, which it certainly isn't today. What is covered? The policy covers claims for monetary damages arising from wrongful acts. Notice that I underline the word monetary. It does not cover things that are not monetary in nature. This is not a substitute for the general litigation budget of a municipality. Its focus is strictly on matters that involve monetary damages, and it really comes in two pieces. The biggest piece, at 80%, is employment practice liability, which deals with employment-related discrimination and retaliation for the most part. The other piece, which is about 20% of the total, is public officials liability, which is land use and ADA issues. Now, when these policies were first issued, the relationship was exactly the opposite. In other words, 80% of the cost was public officials, only a small piece was employment practices. It's reversed, and it's not because the employment of the public officials has gone down. It's continued to go up. It's just that the employment practices has gone up so much faster, as we saw earlier, again by a factor of 11 over the course of the last 10 years. What is not covered? The policy will not cover claims that are normally covered by other policies, even if you don't purchase those other policies. Those are absolute exclusions in the policy. It does not cover punitive damages, fines, or penalties. Under public policy here in New Jersey, that cannot be covered by insurance. It does not cover fraudulent, dishonest, malicious, criminal, or knowingly wrongful acts or omissions. It does not cover willful violations of statute, ordinance, rule, agreement, or judicial and regulatory order. In other words, if you intentionally do it, and you know it's wrong, then it's probably not going to be covered. In the public officials liability piece, some special exclusions. First of all, it will not cover injunctive relief. Injunctive relief is a lawsuit that is, essentially demanding that the governing body do something or not do something. It's not monetary damages. We said earlier, this policy only covers claims for monetary damages. It does not cover liability assumed under contract. For a very simple reason. If it did, and you were in a contract you didn't like, all you would have to do is violate it, and the damages would be paid for by the insurance. So it would be a way of getting out of the contract. We call that a moral hazard. In other words, the existence of the insurance creates behavior that encourages lawsuits. So you really can't cover that. For the same reason you can't cover breach of contract, it will not cover the cost to modify real property to accommodate disabilities. Remember we said earlier, public officials liability, one of the main things that it covers is ADA lawsuits. If you didn't have that that exclusion, and you needed to have your, for example, town hall improved or sidewalks and curbs changed to meet ADA regulations, you would just simply ignore it, wait for the lawsuit, and then turn the problem over to the insurer. Again, it's a moral hazard, so you can't cover that. That's the reason for that exclusion. And it will also exclude inverse condemnation. What inverse condemnation is, or a good example would be changing the zoning of something to significantly reduce its value. Again, that's something you can't cover because, again, the existence of the insurance would create the behavior that results in the claims. Employment practices, again, will not cover injunctive relief, will not cover liability assumed under contract, will not cover breach of contract, and it does not cover lost benefits. In other words, let's say you were in you had employees, you changed the benefit package, they sue you because of the change in the benefit packages. If you didn't have this exclusion, the insurance would then have to come in and pay for the reduction in the value of the benefits. Again, encouraging behavior that results in claims. Something that just simply cannot be covered. However, keep in mind that to some extent the duty to defend is broader than the duty to indemnify. But there's even limits on that. For example, under no circumstances will the policy provide a defense in criminal court, even if you are subsequently acquitted. So in other words, if the feds come around and take you away in handcuffs, and you spend $800,000-900,000 defending yourself and you're acquitted, you can't come back to the policy and say, I want my $800,000 or $900,000. Policy will not cover defense in criminal court under any circumstances. That's an absolute exclusion. It will provide a defense in civil proceedings, even if the allegation is criminal in nature, until an investigation or court decision determines that the alleged wrongful act was in fact intentional. And at that point, the defense is cut off. But again, no coverage under any circumstances for things that occur in criminal court. Now, a couple of years ago, because of the tremendous increase in the cost of this, we decided that instead of self-insuring this line of coverage, we would go out and see what the insurance industry would offer us. And in fact, a number of insurers came out with fairly attractive quotations. The one with the most attractive quotation was XL. And they first of all offered us a 2-year rate guarantee at 2010 rates. We were otherwise looking at a very substantial increase in the premium. They agreed to use the Mel's policy form and attorney panel. They agreed to maintain the risk control incentives, which they will talk about later on. And they offered an employment practices helpline where you can, if you use this line, you can go on and get legal advice from an EPL attorney if you've got an employment issue that you need some advice on. As I say, a very attractive proposal. But notice that the rate guarantee was only for 2 years. And 2 years is up at the end of this year. So we're out to do renewal quotations now. What that's simply going to mean is that those joint insurance funds that had good records will see a favorable renewal. Those joint insurance funds that did not have good records may see something less than a favorable renewal. We'll have to see what the final numbers come out at. But keep in mind that I do have the infrastructure in place that if we have to go back and start self-insuring this again, we can do that. So we're not going to be held hostage to the insurance companies. But we're in the process of doing the renewal negotiations now. In terms of how the policy is set up, first of all, the basic limit is $2 million aggregate. Now, what does that mean? That means you have $2 million of the coverage no matter how many claims you have. If you have 10 claims, that means you have $200,000 per claim. If you have one claim, that means all $2 million can go to that one claim. Okay, but it's an aggregate. And for that reason, there's also optional additional limits up to another $8 million excess of the $2 million basic limit that are available through the program. You need to talk to your risk manager about what types of additional limits you are purchasing, because as you see from the newspapers, claims going over $2 million are now unfortunately becoming very common. You need to be concerned about that. And then they offered optional coverage for past and future wages, which is normally an exclusion. The coverage was offered on a shift-by-shift basis. The Bergen shift took a look at the proposal, frankly came to the conclusion that the coverage was minimal and the cost was very high, so they elected not to take that. And the reason why this coverage is difficult is because, again, it's a moral hazard. Again, if you want to get rid of somebody, you just force it to court, and they pay the past and future compensation that goes along with terminating that employee. So it's a very difficult coverage to write. And so the Bergen shift, as most shifts, elected not to take that option. We talked earlier about risk control incentives. We are in the process of completing that program now. Every 2 years, Communities, in order to qualify for the incentives, need to update their policies and procedures manuals and their employee handbooks. There are models on the website, incidentally, njmel.org. The last time we went through this drill, incidentally, 89% of the municipalities qualified for the incentives. You need to train managers and supervisors. To make that easier, the fund attorney, Russ Huntington, comes around and does that training for you. You need to offer training to all employees. To make that relatively easy, we put out a disc with a new video that we've shot, along with a training guide. And then you need to sign up for the Employment Practices Helpline that I referred to earlier. You don't have to use it, but you have to sign up for it. And those are the things you need to do in order to qualify for the incentives, and the deadline is coming up on May 1st. What are the incentives? Well, the first thing is that the deductible is considerably low. If you qualify for the incentives, the basic deductible is $20,000. If you don't qualify for the incentive, the deductible is $100,000. That's a major difference. These policies sort of will work like a health policy, in that there's also a copay after you meet your deductible. The 20% copay, if you have the incentives in place, are capped at $50,000. There is no cap on the copay if you don't have the incentives. And then there's a risk control premium credit. So let's give you an example. Let's say you had $1 million claim. Now let's just say hypothetically that it's split evenly between compensatory damages, lost wages, punitive damages, plaintiff's attorney fees, and defense attorney fees. In that example, $600,000 is covered, $400,000 is not covered. What's excluded would be lost wages and punitive damages. Remember I said earlier that about half the total cost of these claims are not covered by insurance. This is an example. Now this is before the application of the deductible and copay. If you qualify for the incentive, the deductible is $20,000, the copay is 20% of the next piece up to a maximum of $50,000. So in this case, the amount that's covered is $530, the member share is $470. If you don't qualify for the incentives, now the amount that's covered by the insurance is $400, the member share is $600,000. So it makes a substantial difference if you qualify for the incentives. And as I said, 89% of the members did. And if you have poor experience, the deductibles are either $75,000 or $150,000, and there's a poor experience surcharge. I might add that most of the members with poor experience that trigger these higher deductibles would probably not be able to get insurance in the regular marketplace. Now, in these seminars in the past, we've talked about the need for an indemnification ordinance. I believe most of your communities have that, although every one of you should be personally aware of the terms and conditions of that ordinance. We just saw the samples of why it's important to have the indemnification ordinance in place, because there will be circumstances where the insurance will not completely cover a claim. And so this is what's going to protect you personally if you're named in one of these lawsuits and there's a substantial deductible or copay. If you have an indemnification ordinance in place, that'll be paid for by the government. But even here, there are some circumstances that the indemnification ordinance will not cover you. For example, if you're dealing with something that's criminal in nature or something of that nature. Same exclusion. Let's go through a couple of frequently asked questions. Can you assign your own attorney to defend the cases? Absolutely. However, the insurance is only going to pay for an attorney that comes off of the panel. Every CHIP has its own panel. That panel was vetted to the fund attorney, Russ Huntington. So if you want some influence on what attorney is assigned to a case, what you do is you talk to Russ, and then Russ will make the recommendation to Excel. All attorney assignments have got to go through Mr. Huntington. And that's now there will be some circumstances, particularly if you're dealing with a large potential for punitive damages or something of this nature, that you still may want to assign your own attorney to be co-counsel. But then again, that will be at your expense. If an insurer negotiates a settlement, do you have to agree? No. There's a provision in the policy that allows you to reject the settlement. You don't have to approve the settlement, but you can reject it. However, if you reject the settlement, the insurer's obligations are capped at that point. So if the claim ends up costing more, either through higher legal fees or a higher settlement amount, you are on the line for that additional amount. So as a net result, it is very rare that anybody rejects a settlement. I think in doing this over the course of the last 15 years, I've seen exactly twice, or exactly 2 times, when somebody rejected a settlement. How long do you have to pay the deductible and copay in the uncovered portion of the claim? Depends upon the JIF. The court is going to demand quick payment, which is going to be a problem for a lot of towns because it isn't going to be in your budget. You can do an emergency, but it's a problem. Some of the JIFs, including the Bergen JIF, have put a program in place where you can apply to the JIF, and the JIF board can agree to cover the deductible and the copay, and then bill you back over the course of several years, beginning the subsequent year. Sort of a cash flow protection program. Not all JIFs have it. The Bergen JIF, however, has put that in effect. Can you appeal the decision made by the insurer? Absolutely. Several ways. You can either go through the executive director, who can talk to the insurer, and if that doesn't work, then you can go to binding arbitration. So those are the policy. Okay, let's talk about employment practices. As we said, there's been a huge increase in the cost by a factor of 11 over the course of the last 10 years. What's going on? Does everyone recognize the name John Farmer? He was the one who drew the congressional lines. He's also the dean of the law school of Rutgers University, former attorney general of the state of New Jersey. What he has pointed out, and it's been rather obvious, is that because of the way we pay attorneys, we are encouraging excessive litigation. In a normal liability case, if you lose, you pay the plaintiff and you pay your attorney. In one of these cases, you also pay the plaintiff's attorney. Everywhere else in the country, there is some relationship between what the plaintiff attorney gets and what the plaintiff gets. Not here in New Jersey. In New Jersey, if the attorney wins, the attorney gets to charge all of the hours that attorney spent on the case. Really without any cap, but if it's related to the issues of the case, usually at about $300 an hour, plus an enhancement. And again, no relationship at all between what the plaintiff gets and what the attorney gets. So we've had cases where, for example, in one case, it was a nothing case. We offered $75 to get rid of it. The jury awarded this officer $20,000. We win, right? The application was $671,000. The attorney was awarded $450,000. In another case, the plaintiff was awarded $1,500. The attorney was awarded $155,000. So if you know that all of your hours are going to be paid for at $300 an hour or plus, if your client gets anything at all, then the motivation is to pile it on. Many depositions, motions, all with the idea of building up the number of hours. And you furthermore have got an incentive to be unreasonable, forces the court, as opposed to settling it. Because again, it's going to build up the number of hours. We've created a incentive, actually, for people to be unreasonable. So if you take a look again, that chart of how the costs have been increasing, it's directly related to this fact. And again, only in New Jersey. You don't see this elsewhere. Let's talk about the different kinds of cases. The early cases were what we call the "to the victors belong the spoils" cases. In other words, political discrimination. In New Jersey, in other states pretty much, but in New Jersey in particular, The only people you can hire or fire based on their politics are your manager and your attorney. Everyone else is protected. And even under some circumstances, they are protected. And I'll show you the case later on. So, for example, let's say you have a new council comes in and wants to sweep town hall clean. And let's say hypothetically your clerk is up for reappointment. And let's say and this has actually happened, where the clerk is, clerk's husband was a campaign worker for the other side. And you sit there and you say, well, wait a minute, we're talking about a reappointment situation. The clerk is an employee at will. Once it's not a reappointer for him. Guess what? The courts are going to see right through that, and they're going to say, no, that's really political retaliation. And yet, theoretically, the employee or the clerk is an employee at will, but not under this circumstances. You still cannot retaliate against that individual because of their politics. Every year we have one of those cases, and it's the reason why I bring that up. So, only municipal attorneys, municipal managers, and even under some circumstances, even they're protected. The next group of cases we had were the equal opportunity cases. I mean, in all candor, the only reason why you have women in a lot of positions in municipal government and minorities in a lot of positions is because we have laws that say you can't discriminate against them. These lawsuits are very important in terms of breaking down those barriers. I mean, I was involved in local government long enough ago to remember the lawsuits where women were trying to break into ambulance corps. Yet, if it wasn't for women in ambulance corps, many of them wouldn't exist today. And that was a major lawsuit going back 35 years ago. We don't see as many lawsuits today because I think most people recognize that kind of overt discrimination just doesn't happen anymore. What we are seeing is the disparate treatment where people are treated differently. A classic case involved a minority policewoman who was let go at the end of her probationary period for an unsatisfactory review. Now that in itself is a completely proper major personnel action. However, when they went in and investigated, they found out that lo and behold, there were non-minority officers over the years who had equally poor reviews at the end of their probationary period who were allowed to continue. At that point, it's disparate treatment, very much illegal. So you've got to be very careful that you treat everyone the same in like circumstances. It's not going to be a surprise to anyone that 65% of these cases are coming out of one department. Anybody want to guess what department? Okay. What does every new officer ultimately want to be? Chief, right? And if something bumps that officer out of the chain of chairs, it's because I've been retaliated against. I gave a ticket to the council member or whatever. So the hiring and promotional process needs to be very carefully thought out. Our recommendations are as follows. We want to adopt a police promotional ordinance. Incidentally, we are just about to publish a model on the website. We'll be sending a notice out to everyone when they notice when it's posted there. We're working with the Chiefs Association and a battery of attorneys around the state to draft a model. We recommend that you retain an outside agency to interview candidates. And we also recommend that if you're not civil service, retain an outside agency to conduct a written test. Basically, what you want to do is you want to insulate yourself as much as possible from that process, professional. Okay, so that you can't personally be accused of favoritism. And if there's been any run-in between you and any one of the candidates, get away from the table as fast as you can. You don't want to be involved in that process. And when I say get away from the table, I mean get away from the table and get out of the room. So no way to question your involvement. This was another case that really opened everyone's eyes. This involved one of the early police women in a town actually very close to this one. And she got the usual hazing, got fed up, asked her senior officers to do something about it. They didn't. If she got an attorney, she would have been happy actually with an apology and a good faith effort to deal with it. The town decided we're just going to fight it out in court. The jury awarded her $1.1 million in compensatory damages and gave her attorney $700,000 in legal fees. The town also spent $1 million to defend the case. Again, this one woke up everyone's eyes about the problem of employees harassing other employees. And now that's the basis for a lot of these lawsuits. Here's another case that really woke everyone up. A secretary in the police department got fed up with the chief, quit because of this harassment. The judge ruled that that was constructive discharge, allowed a harassment lawsuit to proceed. The jury awarded $26,000 compensatory damages, $450,000 lost wages, and $900,000 in legal fees. This was the first case where you saw legal fees substantially in excess of the underlying award. Again, eyes now are wide open as people realize that there's big money to be had playing this game. In New Jersey, and actually in the rest of the country, an employer is responsible for the harassment of one employee against another employee unless the employer has an effective anti-harassment program in place. And in a series of decisions, including Lehman versus Toys R Us and Gaines versus Polino, the courts have defined what constitutes an effective anti-harassment program. It includes policies and procedures prohibiting discrimination and harassment. That, we said, is a model that we have on the website. The complaint structure, both formal and informal, that's built into the model. Training, which must be mandatory for management, that's why we have Russ Huntington coming around, and provided to all employees. That's the disc that I talked about. A monitoring mechanism. In other words, you can't just simply put the program in effect. You've got to go down and talk to people to see whether it's working or not. And then finally, a non-equivocal management commitment. That's one of the reasons why we have these seminars, so that we can demonstrate that in terms of the attendance records. So people started putting these programs in effect. The lawsuits started going down, and then wham, this lawsuit comes along. It opens up the floodgates. In this case, you had a DPW worker who was upset about the pigeons in the DPW garage. Started complaining about that. And he started getting teased by his fellow workers for being pigeon man. Now, this town had an effective anti-harassment program in effect, thought it had a good defense. The judge ruled that because this employee had complained about some wrongdoing, i.e. the pigeons, that he was also a whistleblower and allowed the statute to proceed under the CFIUS Act, Conscientious Employee Protection Act. And you see what the jury award was. $400,000 punitive, $250,000 compensatory, and fined the town $10,000 for not doing enough to stopping the teasing. And now all of a sudden everyone realizes that the real statute that is potentially very dangerous in the state is CFIUS. That's why you see virtually every lawsuit now, the main complaint is CFIUS. We'll talk about a few of those. So, who's a whistleblower and what is retaliation? The original idea was to deal with the Serpico situation. It's gone way beyond that. Who's a whistleblower? Everywhere else in the country, a whistleblower is somebody who complains about some sort of substantive public harm, violation of law or public policy or something of that nature. In New Jersey, however, we didn't take that approach. In New Jersey, the courts have ruled that it's anybody who exercises their freedom of speech. So if I'm a council member and if I'm a police officer and I go to a council member and say, I think we ought to have 12-hour shifts. And the chief finds out, and the chief gets all upset for going around the chain of command and reams me out. Guess what? I have a suitcase. What is retaliation? Retaliation, everywhere else, has to be some form of a job action. Here in New Jersey, it is anything which has a chilling effect on the exercise of the freedom of speech. We've even had cases where a DPW superintendent invited all of his employees over to a barbecue on Saturday, except the one person in the department that was the pain in the tail. And the failure to invite that person to the barbecue was allowed to be presented to the jury as evidence of retaliation. It's that broad in New Jersey. So you can assume that everyone is a whistleblower. And you can assume that it's highly likely that they're going to find something where there's retaliation, or at least going to allege it. So let's deal with some specific suits. Remember I talked about that policewoman who won the substantial award in the neighboring town. Well, obviously she had the support of some of her fellow officers. One claimed that as a result of testifying on her behalf, he was discriminated against. The town didn't take that one seriously either. You can see the results. $1.6 million in punitive damages, $2.5 million in compensatory damages, and legal fees on top of that. Incidentally, the town did not have insurance. Fortunately, was not a member of the Joint Insurance Fund, and I think had to bond something like $6 or $8 million to cover the cost of these two claims. Can you imagine the bond hearing on that? Explain to the public why it's bonding that kind of money for two lawsuits. This shows you how far it goes. The prosecutor in most small towns is not really a full-time employee. They're usually members of local law firms. However, they're treated as if they are employees. In this case, you had a prosecutor who complained that the judge was having a few too many nips before coming into the Ninth Court. She complained to the Ethics Board. When it was time to reappoint her, guess what didn't happen? She sues and was awarded $828,000 in punitive damages, $552,000 lost wages, and $1.2 million in legal fees went to her. So in other words, even if somebody is, a at-will political appointee, if what you're doing to that individual can somehow be tied to retaliation for exercising your freedom of speech, guess what? You're going to get sued, and in this state, you're going to lose. This is a local case. You had a detective, sergeant, thought he should have been a lieutenant, files for civil service for a desk audit. Yeah, civil service comes in and says, no, properly classified as a sergeant. This sergeant did not get along very well with the chief. So sometime later, the chief transfers this sergeant involuntarily out of the detective bureau and into the patrol division. Same rank, same pay. But guess what? In New Jersey, involuntary transfer out of the detective bureau is in fact considered a retaliatory job action. And there's past precedent on this. There's something about the prestige of walking around with a gold badge instead of the 10 badges. Takes it to the jury. Unfortunately, the case was just not limited to the retaliation. The judge then also said that the plaintiff's attorney could re-argue all of the issues relating to the desk audit. Now that was the surprising part. arguing about whether this guy was retaliated against for being transferred out of the Detective Bureau, that was certainly legitimate under SEPA. But allowing the plaintiff's attorney now to go back and re-argue all the issues that were decided by civil service, that was a major extension. And the jury came back with $125,000 in punitive, $320,000 in lost wages. And so, no lost wages, same rank and everything, right? And $100,000 emotional stress. The attorney's fees in this one were minor, $160,000. The obvious point is that now SEPA is being used to really fight out any kind of minor employment squabble. Okay, so what we need to do is we need to change our culture. We need to start at the top. Everyone from the mayor and council to all the senior managers need to know what the rules are and understand them and follow them, both their letter and the spirit. But we also have to make it very clear to the rank and file that all the little notes in the lockers and all the petty retaliation that used to go on, that's no longer acceptable in today's environment. We also need to change the, frankly, the attitudes in the courts. The courts have got to have a better understanding of what this is doing in terms of the operation of municipal government. We're getting to the point that it's very difficult for managers to manage anymore because of the fact that everything is now being second-guessed by the courts. And we need to change what's going on in the legislature. And particularly, we need to put a cap on fee shifting, and we need to bring SEPA back to what it was originally intended to be, as opposed to what it's now become, which is kind of a catch-all way of fighting out any kind of a squabble. And as I say, until we start making some of these fundamental changes, this problem is just only going to get worse. You read what's going on in the paper, every week, and it becomes obvious what the problem is. Finally, let's talk very briefly about public officials' liability. What is a NIMBY? What does it stand for? Not my backyard. Cell towers, adult bookstores, mega churches, group homes. Very unpopular with the residents. Guess what? They're all federally protected. You just simply cannot say no. You've got to be very careful how you deal with these applications, or you're going to end up in court and you're going to lose. Be particularly careful about any land use application where you may have a personal interest. In this case, you had an application for a small commercial center that was going to include a daycare center. The application was completely conforming, but the mayor dragged this application on for a long period of time because the applicant and the mayor had been, let's say, less than friendly from about second grade on. This went on for a couple of years. Lawsuit was filed, we investigated, found out, lo and behold, the mayor had an interest in a daycare center just up the street. There is no way that that mayor should have been sitting on this application. There's a clear-cut conflict of interest. Since we found out about that, we settled the case as quickly as we possibly could. Had we not settled it, had this gone to court, there undoubtedly would have been punitive damages, and guess what? The punitive damages would not have been covered by insurance, nor would they have been covered by the town's indemnification. The best thing we did for this now ex-mayor is settle this case. We mentioned that the other very frequent type of case is the ADA matter. This was a case that was relatively local. There are law firms out there that specialize in filing ADA cases. There are certain plaintiffs, one in particular lives in Florida, comes up twice a year just to file lawsuits. And so you got to be very careful about the way laws are written that allow people from outside the state to file lawsuits. We're currently changing, incidentally, our Oprah law. Right now, you can only sue under Oprah if you're a New Jersey resident. One of the changes they're proposing to make is allow you to sue if you're outside the state. Guess what's going to happen? We're going to have people outside the state who are going to set up Oprah lawsuits now, and so in addition to ADA lawsuits. You know, be careful what you ask for, you may get it. Anyway, what happens is that they just filed these lawsuits. This one came down with $50,000 plus $100,000 in attorney's fees. It's becoming more prevalent. We are going to be having on the website very shortly a pretty thorough discussion of what are the ADA standards relative to municipal government. We need to pay attention to those. But ADA isn't strictly barrier-free issues. It's also employment issues. In this case, you had an EMT, paid EMT, who wrecked his back lifting a patient. He wanted to continue, but obviously could not continue as an EMT. He was told, no, we don't have any jobs. He noticed, however, that they, in fact, were looking for a dispatcher. But he was discouraged. And so he sues. And he gets a substantial award. In an ADA situation, you have an obligation to have an interactive dialogue with a individual about whether you can determine if there is a possible reasonable accommodation. Now, what constitutes a reasonable accommodation is very complicated, and we'll get into it today. And usually you can't come up with a reasonable accommodation in most instances. But you have to have the interactive discussion. If you don't have the interactive discussion, you're wrong, you're going to lose, you're going to pay money. That's simple. That's a part of the requirements. Even going out to bid. In this case, you had a minority contractor who was low bidder for the construction of a firehouse. The firefighters didn't want that contractor, wanted one of their own. They go out to bid again. The minority comes in low again. They still, however, awarded it to their own. The contractor, the minority sues, and is awarded the amount of money he would have made in profit had he done the job. This is an old case. I can tell you that if this happened today, that number would be many, many multiples of that number. But it demonstrates what can happen. Even towing licenses have been the subject of litigation. In this case, you had somebody from outside of town come in and wanting a towing license. He was told, oh no, we're not issuing any towing licenses now because we're redrafting the ordinance. When the new ordinance came out, lo and behold, there was a requirement that you had to live in town. Okay. But there was also a provision that said that if you had an existing license, you didn't have to live in town. You were grandfathered. Needless to say, the judge took one look at that and said, yeah, there's no way this flies. And so we settled for $150,000. And then finally, and I've talked about this case before, but you know, it demonstrates what's happening here and why you need to be careful. This was a case, Secaucus, where you had a gay couple live next to a firehouse, and a volunteer fire company. The firefighters came back one night about 2 o'clock in the morning. They had a bus, so you can imagine what they had been doing at dinner till that hour. And let's say they were maybe a little bit on the rowdy side. And so one of the people in the couple next door asked them to quiet down. There's some dispute as to what was the terminology, but it was essentially quiet down. And it resulted in a stream of abuse that I think we would all find to be very objectionable. The police were called. They could not find out who was in fact responsible. They made a good faith effort to try and say, this was not an attempt to whitewash. But of course nobody was going to tell them. Town took it very seriously. The mayor showed up to the house the next day, had the door slammed in his face. The mayor actually went to the point of asking the prosecutor to investigate. He was fully prepared to prosecute his own firefighters. So he took this very seriously. Well, the long and short of it is that once it goes to court, the law up to this point had been that the town is only responsible if this had happened under the color of law. In other words, where it either been encouraged or condoned, which it clearly had not been. And so it looked pretty good for the defense. Until the judge dropped a bomb. The judge said the town could also be held negligent if the town did not have an effective anti-harassment program that also extended to the volunteer firefighters. And so you see the result. That's the reason why one of the parts of the program is to include particularly the volunteer fire departments and ambulance corps in the anti-harassment program. In fact, we've actually produced a special video that's specifically aimed at volunteers. They need to be included in the process, and you see why. So just to very briefly conclude, we need to change the culture. It has to start at the top. It needs to work all the way down to the grassroots. Again, all of the give and take that was characteristic of the locker rooms and the offices and the shop room floors, you've got to make it very clear that that kind of thing is just simply not acceptable anymore. And we have to put effective programs in review. But we also need to change the culture in our legislature and our court system. We can't do this anymore. And finally, again, the specific things in the incentive, the updating of the policies, procedures manual, employee handbook. Part of this, incidentally, is the distribution of the letter concerning whistleblower and complaint structure that's put out by the Department of Labor and Workforce Development. The training of the managerial and supervisory personnel, that's of course what Wes Huntington does, providing the anti-harassment training to all other employees. That's the video I talked about earlier, and the signing up for the BPL hotline. Again, the deadline for that is May 1st. I think it's May 1st. Anyway, and then finally, I put this up every year, and I've got to emphasize it. Seek the advice of your municipal attorney before you do so. This has got to be very, very complicated, and you need that person's advice. And insist that that attorney tells you what you need to hear, not what you want to hear. We've actually had a lot of lawsuits, frankly, where the advice that's come from the attorney to the counsel has not been very candid because the attorney was concerned about what the counsel could say. You don't want your attorney sugarcoating any of this. And then finally, watch what you say, especially in executive session and in electronic communications. More cases are lost because of emails, Twitters, and all that. At this point, about 5 minutes before the end of the hour, are there any questions? Everyone signed up?
I had a question.
Yeah.
You said 89% of municipalities qualified.
Yeah.
How do we know where we stand? Or is there a list?
Yeah, I would ask your administrator. I can assure you that you're qualified, and your risk manager.
We have a favorable JIF record?
Yes.
Now, all this stuff, do we do all this, hand out the whistleblower things and policy?
Or you've done, you'll see on the consent agenda, and others could hand to the volunteer and thank them at the same time as they come in, like a receiving line. Often they go to the festivities rather than having to try and find Sally Smith, or and say, right. Yeah, it's probably better with the the late notice to just have a generic certificate. We'll see. Maybe the library can accommodate.
We'll have to see with to really get it out there. 2 weeks is a bit tight.
Well,
we can get it up on the board.
We'll get it up on the board, and email will put it on the patch.
How many people can the library hold?
200 inside.
Huh? Yeah, especially, I'm saying, if it
People are
rains, how
gonna
many
go in
people?
the front door and go out the back door.
I mean, if
With
it's a
the certificate in
circulating
their hand
thing,
and a
people are not
piece
going
of
to hang
food.
for 2 hours.
You get parking, you gotta get the police involved. Yeah, but people are gonna see who the people they know, they're gonna start talking, they're gonna start chatting, and then people can't get into the library now to get their certificate.
That's called community.
We don't know that we're going to have
I
a
think
flow. Why don't we just try it?
I think you can, I just think that, you know,
It could be a disaster, but it's a nice thing to
if
try.
it gets packed, you'd be...
So
So
skydiving.
do you
It
want me
could be
to
an-
direct Bobby to ask
unmitigated
the president of the league
Yes,
to
I
invite
count on
the
Sunday.
coaches? Is that, are we talking coaches?
Coaches and volunteers, yes.
Right. So I can ask her to, but you have to let me know if it's the
Boards and
definite, before
commissions.
she asks the
I don't know.
presidents of the leagues to email these coaches.
How are we defining volunteer? Is it someone who just does something for the town, or a town activity? Is it someone who volunteers for, you know, a charity? Not
No, a town
necessarily as-
activity. I mean,
It has to be a town
they-
activity.
Yeah.
Okay, so
Well,
we're not...
I want, except that we wanted, let's not say we, I thought that we were opening this up to Boy Scouts, which is not a town activity, Girl
Mhm,
Scouts,
mhm.
Brownies, which are not
Well,
town
that is a town activity.
Yeah, service groups.
They do so much around the town, I mean, you know.
Yeah.
What about boards and
Who have
commissions?
those names?
I have those names, yeah.
Boards and commissions, if,
Yes,
you know,
those
the
would be
planning
volunteers.
board or
Well, no,
the zoning
they're
board.
volunteers, so...
Yeah, the
Yep.
historical beautification, they're all included.
Because they're doing a lot for the town. It's a good idea.
They do a lot. I mean, all these volunteers that are here for meetings that go after 11 o'clock some nights.
And that's millions of dollars in money that, you know, they've devoted to take care of things, when you add it all up.
And it's a nice idea. If we're standing at the door, all of us, handing out awards, welcoming people in, that
You
will
don't
keep
want-
them moving.
You're not writing any names on it, you just want to...
I think
Yeah, just
generic is best at this
Go
point.
generic. I'd like to see
Sure.
everybody show up. This is not a nonpartisan event. It's just good for the community. Get everybody together at the beginning of this, at the beginning of the spring, so everybody can roll up their sleeves in time for the baseball, softball, t-ball, beautification. They all get going now.
What time, if I put this on the website, what time? are you-
1 to 3.
I'm sorry?
1 to 3.
1 to 3.
I think River Edge Day sounds better, personally. I think it goes along with the event pretty well, but that's just...
Well, they'll probably get muddled in River Edge Day. This is, you know, just on its own volunteer day.
Yeah.
River Edge Day's got a lot of stuff going on.
All right. So just to keep on everybody's agenda, Sunday, April 15th, 1 o'clock, the library.
Do we have any postings on it, or is it,
I'm sorry?
any postings, does people know about it, or?
No, that's what we're talking about, no?
It'll be posted tomorrow.
It's going out. It's going out.
You want to push it back 2 or 3 weeks, just so we can get a little more information, or you want to do it then?
Now, that's...
Well, that's the actual, like, week of the,
Says who?
says that if you Google it.
It's national holiday.
It's National Volunteer
Yeah.
Week.
We have a proclamation.
We have it on for proclamation for Monday.
Believe it or not.
No, I believe.
All right, next item, work session, consent agenda. There are 4 items. They're all changes to our personnel policy and procedure manual. Number 1 is regarding email and internet code of conduct. Number 2 is changes regarding the American with Disabilities Act. Number 3 is the benefits flexible spending account. And number 4 are personnel records. So these will be on for formal resolutions on April the 2nd. Can I have a motion to move the consent agenda?
So moved.
Second.
Any discussion? All those in favor?
Aye.
Any opposed, any abstained? All right, good. Council reports, any council reports? Kathleen?
Okay.
Paul?
No.
Johnny?
No.
Ed?
No. I could, but I'll save it.
I have a bunch, I'm also going to save it.
You
till next week.
disappointed me, Alan. You always have a report.
I got a bunch too, but I'll save it.
I do, but I'll save it.
All right, mayor's reports. I should have written down some notes.
You should save yours too, John.
What?
You should save yours too.
Save mine too?
Yeah, make it a bigger, production.
In a minute,
We have
we'll
Chris
have a motion to
Crassus
adjourn.
here. He wants to say something, Paul.
I guess report I could make is that Ed knows that on the planning board, we received an application for a CVS on Kindercamack
Yeah.
Road. So, I'm sorry, 7-Eleven.
It's a reapplication, it's a resubmission,
Oh, okay.
a modification of a pre-existing
Right.
application.
Is that the one started by Johnny P?
It's coming.
So, that's coming down. Did everybody see the report on, the environmental report on the Ciancia Brothers property?
I had a question about that. The guy that I spoke to, he said they actually have to do air quality testing of the apartments as well.
Really?
Mhm.
Wow.
So I don't know if there's a follow-up with,
I'm sure there's going to be follow-up, but
he said the surrounding apartments need to have that
it
done.
wasn't good news that the readings were so high, so,
I was on the phone with Peter today, Ciancia. It looks like the editor's article that Chain Store Edge wanted to do was going to go through. There was some concern Peter had, and he had put off the article. Looks like that's going to move through. Peter also said that, in the previous conversation I had with him, that there's no obstacle or impediment to him to start building, even now. He still does not have any signed leases. He still only has letters of intent. But we're hoping that this national, and it's I'll say it again next Monday, that if that attention will help push interest, that's what I'm hoping for, and move things forward. He's still saying that he thinks he'll start building in the beginning of the summer, because there is no impediment to him building even at this point.
all right. Also wanted to mention that we have a signed contract now with Capital Alternatives, right, Alan?
Right, Denise?
So, are we going to invite them back to talk about specific grants? Don't you think we should do that?
Mayor, I think, they would like the council to develop their focus, to what your they're going to come and ask us what our priority list is, and what areas we would like to see grants.
Right.
In the past, they've also asked for representatives of the council, a contact, basically, a liaison between the council and them to work back and forth. And then, of course, we can alert our departments, and they will go department by department and speak with them about what their needs are.
All right.
So I would just encourage the council to try and think about what your priorities are over the next year in terms of where you would like to see the grant effort made.
I think we all agree that it would be beneficial to try to get some grant funding for the drainage on Voorhees. That's a good option that I think we probably have a consensus on, because we have we'll put 100,000 into capital already, so there might be an opportunity to get some of that back.
What about the Fifth Avenue? Did we go forward with that for the street repair?
Mayor, if I may?
Yeah.
When the applications come out, we will be making application for that. I've spoken to Bob Costa about that.
Anybody? Al?
Yeah, just on that front, Recreation Commission is interested in contacting Capital Alternatives for a grant for the lighting down at KVG. So that was something that they wanted to discuss with them.
Okay, that's a good one. That's a big ticket item. Ed?
I'd look for, like pedestrian improvements, crosswalks, countdown timers, things near bus stops, just for some pedestrian safety, because we've had issues down, particularly at Midland. And that's be under safe routes to schools or safe routes to transit or
Yep.
something.
There are still some curb cuts and handicap ramps that are not in on certain, they're not main streets, but I know that Wayne Avenue, near the entrance to the back lot of the Cherry Hill School, those curbs are in bad shape and they're not cut and there's no ramp, so that'd be a good spot for something like that, because it's in close proximity to the school. Maybe that could be part of a grant for those curb cuts and ramps. Johnny?
As far as these grants, I thought that we were going to be, I just want to make sure that we're going out for only things that we are already slated to do. So something like the lights down at KBG, I don't know how we would word that, in the sense that, okay, they come back and they got 200,000, and that's all well and good, but we still got to come up with whatever other money, plus give them their fee. We don't have any money set aside, so now we have to come up with additional monies. The Voorhees, I get, that makes sense. We had 100,000 set aside, so whatever money is free money to us,
Right.
that's great.
Right.
But something like KBG or something like these other things, I just want to make sure that we were going to do those projects, or we have money set aside for those projects before we start asking them to get grants for them, because if they do come back, we don't have the money to pay for the rest of it or pay them in these scenarios.
Well, they get paid out of the grant.
What they
money.
get. You scope
No,
the
you
grant,
can't.
you scope
Wait,
the project
one at a
based on...
time, Ed, and then Al.
You scope the grant, you scope the project based on the grant amount. So if you get $100,000, you take off their 20, and then you could do it that way. We've done that.
You can also do it in stages. You can get a grant to do half the lights one year, and then go out for the same grant the following year to do the second half of the lights. You just, exactly what Ed said.
Just on that point, Recreation views it as a multi-year project in terms of getting money, banking money, and then, once the money's in place to do it. Along that front, and this comes up with REC and beautification, some of the other groups, they're curious about open space being on the ballot for this year. I think if we're going to do it, we should do it sooner than later, so that our groups can start to, get out there and be vocal in support of it if this council is going to vote to put it on the ballot again in November. The sooner we get it, we say we're going to put it on. I think we have until like August, right, Alan, or something like that.
How quickly can we put it on?
July, we used to do the resolution by July.
Yeah, so, there's no reason we can't do it now.
That's right, there's no reason.
So... if
So
we're
can we
going
do
to-
it now?
Yeah.
Yeah.
So let's do it now.
Well, we have to...
A motion, and we'll put the resolution in front of you.
We'll put it on for a formal resolution.
No, I'd make a motion
I would
that at the
second that
next
motion.
meeting, we have a formal resolution to put the open space on the ballot for November.
Let's say that that's number 5 added to the consent agenda.
Just a point of
We have-
clarification there.
Yes.
Will we be using the last resolution that we put before the public? You're not anticipating any changes? Okay.
I was fine with the last one.
Okay, good.
Any, Johnny?
Are we off the
Well,
open
there's a
space?
motion, there's no second yet.
There's a second.
Second, okay, now we're open for discussion. Johnny?
No, I'm going back to the grants, because I'm not done with that part yet. We skipped over the grants and went to open space, but okay. So tell me when we're back, and then I'll...
All right, let's have
Roll call.
roll call.
Councilman Murphy?
Yes.
Councilman Quartz?
Yes.
Councilman Porco?
Yes.
Councilman McMillan?
Yes.
Councilman Bartoloni?
Yes.
And Councilman Capoleto?
Yes.
All right, it's on the consent agenda for the April 2nd meeting, the same language we used the last time around. All right, now, John, you
So
want to...
I just want to clarify, so if we get a grant for 100,000 and their fee is, let's say, 20%, I don't know if that was exactly it, but...
10%.
Okay, 10%, so that's 10,000. That means that we can give them the 10 out of the 100, so we get 90 and they get 10? Is that true?
I'm not so sure about that.
Okay, so then we still have to come up with 10 grand if they get us 100 grand for KBG.
It depends on the
Year over
grant.
year.
Depends on the grant.
Depends on the grant.
But we're not going to ask them, okay, or are we going to ask them to go out for these grants where their fee can be out of that? I just don't want to come into, they got us 300 grand, and we come up with
No,
30,000.
I agree with you. I don't
Usually, we didn't hear it from Capital Alternatives' mouth, but usually, when the grant is awarded, they want to get paid. Right, Alan?
Yes, and this
I mean,
is
if
why
we have-
I've
yeah.
made it I've asked for a condition that we put something in the budget that we can set aside for them so that we are prepared to meet our obligations when and if that grant is awarded to us.
And we did put money aside for that, right?
Yes, we have 15 set aside.
Okay.
Their paperwork, though, says that they don't get paid till they get the grant.
Yeah,
So-
when the grant gets awarded, that's not, that doesn't mean that we've got the check. It just means the grant gets awarded.
Right.
Then we have to go out to bid. That's a process. We have to have pre-construction meetings. We have to get any legal or engineering done. Then when we're ready to go, we could request the money. But by then, you're months later. So they want to get paid when the grant's awarded. Once we've developed a more, a relationship with them, they may wait for the money, but I don't think so.
It seems like a lot of the ADA things, is there somebody that goes around making sure that we're compliant with everything? Because it seems like you're open to a lot of risk with lawsuits with the ADA, especially that door downstairs. I mean,
Is that grant money?
Yes, that's
Yeah.
Community Development Block Grant money. We have, for many years, been conscious of the ADA requirements, and as we have done improvements, we have, addressed that issue. I personally, we did 10 years' worth of curb and ramp work throughout the town over a 10-year period to get virtually as many ramps in place as we could. We have an elevator in this building and an elevator in this building, which were both grant applications done through Community Development Block Grant. The renovations, when they were done here, we had the proper handles put on the bathrooms. We created handicapped bathrooms, parking, so we're always conscious about that. We're always trying to do more. I'm
like
not
if there's
saying we're
one
perfect.
street that does not have a cutout, is that a risk?
Is
No.
there a risk? No, but...
Does
no.
every
Because
street have to be?
You only have to do it if you're doing construction. Like if you're going to pave a street, you have to upgrade the ramps.
Uh-huh.
But otherwise, you're under no obligation
Existing
to fix
streets
it.
don't have to be?
But we've made an effort to try and do that,
Mhm.
and I always say, I don't know that anybody can comply with every law and regulation, but you're obligated to at least make a good faith effort to do
Mhm.
so, and I think that's what we've done over the years, and we will continue to do so. And by the way, on the doors, Denise and I, we received our approval from Block Grant, the environmental review, a verbal review has been done. So she and I have both been working this week on creating the bid specification. You'll have a resolution on April 2nd to authorize us to go out to bid, and we'll get the document out there to get out to bid and see what it will cost us.
This is
to
for the
get
door
this.
downstairs.
We'll have both doors in it. We'll have the Borough Hall door as a base bid and the Public Safety Building as
Why
an
did
alternate.
it's not a historical building, so why did it have to be so involved?
It's part of the review they do. They do a historic review. They asked our commission to get involved, and they reviewed the documents, and we made accommodations to make sure we complied.
We had to do an environmental review for the door. That's a new one.
Any construction.
All right. All right, so when we have in Marlene from Capital Alternatives, the issues we're going to address are recreation, Voorhees, pedestrian, safe streets, what do you say, countdown lights, Ed?
Yeah, that goes with pedestrian safety.
Right. And we'll ask her specific questions about whether the grant applications are for matching funds, which we would have to know ahead of time, whether or not we're going to have to assume that liability, whether or not it can all be paid, whether or not it can be done in phases. Those kind of things are good questions to ask the grant consultant. All right.
Just something on new business.
Yep.
Between, on Continental, there's a lot of foot traffic between Memorial Park and the tennis courts. And there's constantly people going back and forth. There's no, designated pedestrian walkway there, and people just fly up and down Continental. Is there any way to put some type of, designated crosswalk there? Because, it connects the two parks. I know it's in the middle of a street.
Yeah, mid-block.
But it's, people are constantly walking in between the two. And it's just, cars don't stop for anybody. So.
We refer this to the police chief to take a look at?
County approval for mid-block crosswalk.
There's the crosswalk right by the cultural center where you're really supposed to go down.
Yeah.
What about one of those orange plastic things like they have in Oradell on River Edge, on Oradell Ave?
That's like a lawsuit waiting to happen.
What's that?
Putting a plastic cone in the
Yeah.
middle of a...
No, that
middle of
stick that,
Continental.
that warns people that it's a crosswalk.
It's, it would have to be designated, and Ed just told me you have to get county approval because it's a
Mid-block crosswalk.
mid-block crosswalk. But that area is ripe for that. There's so much foot traffic.
It's Continental, a county road.
Doesn't matter, they still seem to have some kind of jurisdiction.
Jurisdiction.
Yes. I dealt them in Fort Lee on, it was a local road. We had to do mid-block crosswalk near our community center in town, and we had to get their approval.
Wow.
Perhaps, a crosswalk wouldn't be appropriate, but again, I would go back to the police chief. Maybe there's some signage we could put up, that would alert motorists that, there's the possibility of pedestrians crossing here without designating a formal crosswalk. Why don't we let the police chief look at it and see if he can come back with some suggestions for traffic calming or something like that?
Good idea.
Okay.
And maybe even some, if you can do, speed bumps. That makes people slow down.
DPW doesn't like speed bumps.
Yeah, ruins their equipment. Sorry, Johnny.
2 items for new business, if we're going there. I was approached by the YMCA in Ridgewood. They want to start expanding some of their programs to sort of this area of Bergen County. And they asked if we would be interested in some programs that they can, they didn't want to compete with our programs, they just wanted to augment existing programs and see how they can kind of, run some stuff here. They run a great program up there in Ridgewood. They wanted to come in, so I just wanted to bring it up and see if everybody was open to it. We can have them come in and see what they're thinking and, if it's park programs or whatever. They just had some ideas that they wanted to start expanding, and I thought it would be a good opportunity for us to open up to new programs. So
Where would they set up shop?
they just want to come in and talk. They were asking me, where do you want, whatever they can do to, increase, programs and stuff like that. And I said we're open. I think we're open. I am. And they said they'd love to come in and talk and see what we want, and maybe they could sit down with rec and other departments. Or,
Do they already know what we offer to
No.
fill in the gaps?
They have no idea. I want to set them up, but I wanted to get them in here to talk to us on what their thinking was. I didn't want to tell them to come in and without, us having a good idea that we're open to it, and then they could come in and speak to us on what kind of programs they had in mind. And
Johnny, did you talk to Bobby about this at all?
no,
Reaction?
I wanted to bring it up here first before, they spoke to Bobby. They made it clear that they didn't want to take away from our programs. They didn't want to compete with our stuff. If we had certain programs that were doing well, they didn't want to, try to compete with it. They just wanted to, I guess if we had certain programs, they would run something else that's something different. So it was completely to augment it. They
So you should probably talk to her to see what we are lacking that they can offer.
It's not, they didn't make any indication that it's only rec, it could be anything, or maybe even,
Is
Yeah.
this a for-profit programs they want to do?
it's the YMCA, so, I I don't know if they're...
I'm wondering how they're
for-profit in
going
that
to
sense.
fund programs in our town.
Oh, they're going to charge, I'm sure.
fee.
There's going to be a fee.
That's what
Oh,
I'm saying.
absolutely, there's going to be a fee.
Yeah, fee-based.
There's a fee up in Ridgewood, so yeah, there'll definitely be a fee. But there'll be additional programs and additional things that people can take part of if they want to.
I guess we'd have to find out locations where they could actually operate.
It depends
Like
on whatever they
buildings
want
or-
to do. It depends on the program. If it's, obviously, if it's something like soccer, you need a field. If it's something
Well, they
like,
do UK Elite here, so we already have that.
like I said, I'm just bringing it up as something to augment our current.
All right, so
Programs.
you have a motion to allow the YMCA to make a presentation?
Yes.
15 minutes before council or something like that? Is there a second?
Yeah, or during work session.
Yeah, during the work session.
I'll second.
All right? Let's have a roll call.
Councilwoman Murphy?
Yes.
Councilman Ford?
Yes.
Councilman Porco?
Yes.
Councilman Mignon?
Yes.
Councilman Bartoloni?
Yes.
And Councilman Capoleto?
Yes.
All right?
And then
Schedule it.
Just had a second thing
Yep.
also. I just wanted to come back to the tax increase for a second. You know, we're at, I just, you know, I definitely am not happy with the 142. I'd like it to be lower. We were at 122, and then we raised it up to the 2% levy in order to put some money back into revenues and things like that. And then Alan was able to save a little bit on some bonding, things that he was able to accomplish, and then we went back to 142. I think if my numbers are right, we were at 122, and then we went up to get to the 2% at 187. Was the 2% tax cap, tax levy, was 187. That was about a $65 difference. So I was thinking we could take the 142 and go down to about $95, which would be about $47. And I know that we wouldn't be, I know it would not be setting us up for next year, but at the same time, I think that $142 is, number one, too much of an increase this year. And number two, I don't think it's prudent to charge the residents to put us in a better position next year. I get if we cut back additional monies in order to, and, you know, revenues came up, then I get it, you can bank the revenues, but, you know, going out to ask for more from the residents to bank for next year, I don't think is the right thing this year. So I'd like to bring it down to $95. That's my thought.
Alan?
Mayor, I'd like the opportunity just to put my recommendation on the record as I've done for 30 years. I've always advised the councils to increase your tax rate by 2 or 3 points a year, and by so doing, you'd create a picture of a stabilized rate with a gradual increase rather than peaks and valleys. I'd like to commend the council for coming to a budget this year that is 2.25% below last year, while holding the salary increases below 2%. The $142 increase will allow you to meet all of your expenses this year, and as Councilman Porco has indicated, put some money back into surplus, not a lot, some money back into surplus, and perhaps avoid the possibility of some revenue deficits in some of those areas. If you want to go down to $95 or below $100, you'll have to come up with approximately $200,000, which would have to either come out of the appropriation side of the budget, or you could push the revenues, the surplus number in the revenues, to try and achieve that figure. Please keep in mind that next year you'll be confronted with the full salary and wages and benefits of the new hires this year, plus step increases. You'll be confronted with a 2% increase for the full year for all the bargaining units. The reserve for uncollected tax will probably be an issue, because if we go to the average again, the 99% from 2009 will drop off. We have tax appeals this year that will probably be in the neighborhood of $150,000 plus. That will affect our revenues. School aid that is going to be given to the schools will help keep those rates down, but by the same token will cut our deferred tax surplus for next year. We want to go to a bond sale next year, which means we'll have to go to the rating agencies and look for a new rating on that particular sale. They will look to see whether we have started to claw back and achieve some surplus number or reserves number to try and hold our AA rating with the Standard & Poor's. So for these reasons and others, I think it is time just to try and make some progress to create a little bit more surplus, to make sure we don't run into revenue deficits next year while still meeting all of these expenses that you're going to have to deal with.
Thank you.
That's my report and recommendation, that
Any
you
other-
stay where you are.
Any other opinions? Al?
Yeah, there's two things. I actually do agree with Johnny on this, to the extent that it's hard to tell people that you're going to increase their taxes more this year, you don't know what next year is going to bring. For 2 years, people have seen municipal increases in excess of $200. In 2010, I think it was $250, and last year it was about $210. So those were large increases. Now, this year it's $142, and I am proud of the budget to the extent that we had a lot of things to overcome, a lot of expenses. And this budget, again, is, $14.2 million is about $500,000 less than this town's budget was in 2007. So that's definitely an accomplishment. We're going forward 5 years later, and our budgets are less. I don't know if the average homeowner understands that, to be quite honest. They just know that their taxes keep going up, and they're frustrated by it. I'm frustrated by it as well. So I don't think it makes sense to put money aside in surplus, particularly if there's no... What I'm concerned about is some safeguard in place, that this council does the prudent thing, it does the right thing, it maybe budgets for the future, and we continue budgeting for the future, but then some later council comes along and wipes out that surplus again, like happened in the past. Before this council starts to generate additional surpluses, I think we need to find a way that we can safeguard surplus so that you don't have councils with 33% of their budget made up of surplus. That's not sustainable, and I don't want to see that happen. I don't want this council to make the hard choices that we have been making for the last 2 years, and then somebody else comes along and, because it feels good, wipes that back out again. I want to know if there's some way we can limit this council, either through an ordinance or a resolution, ability to tap surplus in excess of perhaps 10% of that. The current year surplus cannot exceed 10% of the prior year's budget amount, so that we don't have a situation where this unsustainable practice starts to occur again. Human nature being what it is, I don't want to see political expediency get in the way of good government, and that's something that this council, I think, has really tried to do. Has had good government even when it wasn't good politics. That's what we did paying off the pension deferral last year. That's what we did with the reassessment. It was good government. Maybe not good politics, but I want to see something in place before we start generating surplus again.
Alan? You can create a financial policy through ordinance. In fact, the rating agencies encourage that. They give you points for doing those types of things, because it does codify it, and it does create a certain discipline. Up until now, we've only had some informal policies that have not been codified that way, but certainly the rating, this is a best practice that is out there, that you could come up with a policy and codify it so that this council and other councils would have to stick to it. So we can provide you information with some of those policies.
Okay.
And we'll do that.
I'd appreciate it.
Anybody else?
Just one other point. And again, my other concern is, and Alan touched on this with the tax appeals, the 150 may have to come out of the surplus this year anyway, because it's large enough that it hurts, but it's not so large that you can spread it out, I think is what we were told, right, Alan?
At this point, right?
At this point.
I know, so we've got more.
So I'm guessing it's prudent, unfortunately, to leave that money in place, because we may have to, that money may already be spent, to be quite honest. So, and it's not a great thing, I don't like it, but I think sadly, I think that money maybe is already spent.
So when you pay the tax appeal refunds out of surplus, you're further depleting it, right?
Yeah, but we can't, because it has to be, what do you say, 250, Alan, 250,000 to be able to spread it out?
You have to have a minimum of $50 to the homeowner, so, that's better than 160, that's like, closer to $200,000.
Yeah. Which we're not there. So you have to pay it out in one lump sum. And where else is it going to come from? We're not, I don't know if we want to bond for it. I don't know if it's large enough to bond for it.
There's other rules.
Yeah, so it basically has to come out of the
Well, we have other tax appeals pending, right?
Yes, that's why I say, right now, we have to wait and see, what else happens, as we go through the year a little bit closer. We'll continue to watch it. But the current, using the $142 and the surplus that we have in the budget, that will leave us with $282,000 in surplus, up from $80,000, roughly $80,000 or $100,000 in past years.
Is that historically low for surplus?
That is, I can't find the words to describe how low that is.
Didn't you say we should have $800,000 or $900,000 in surplus?
Yeah, back in 2007, we had close to $1.5 million in surplus.
Right.
I've done cash flow reports for the prior councils, basically saying we need $2 to $3 million so that we don't have any problems. Right now, we don't have money invested. We're basically living day to day with our bills. We have about $1.8 million to get us to the May collection. I have to meet payrolls and make payments on bill lists and school payments and utility payments and things like that. So things are very tight, and at this level of surplus will continue to be extremely tight. And I can't promise you that I'm not going to have to borrow for tax anticipation notes at some time during the year. I can't. We'll have to go out and get cash when we have that need.
Yeah, having surplus at that historically low level is just not good budgeting. Kathleen?
Mr. Porco said $200,000, or Alan, you said that would have to be cut. Where are you anticipating these cuts?
I'm not.
Mr. Porco, what is your idea of the cuts?
Yes, the council.
My idea was that we were at 122. We went up to about 187.
So if we have to take $200,000 out, where are you proposing that comes from?
Okay.
What are you going to cut?
Can I finish before you cut me off? We were at 122. We went up to 187 to hit the 2% cap, and that $65 was the difference in order to get us to the cap. That was put back into surplus or revenues. That's where I'm looking to take it from, the money that we put back after we cut back to 122. We went all the way down to 122. We didn't have to, as far as New Jersey State, we had 2% cap, that would have been 187. We cut further than that. And then we put that money back in to revenue and wherever Alan put it, revenue and other items. So my proposition is that we take it out of there, and we only make it a $15 difference, so it would be $50 would come out of there, or 47 would come out of there. It wouldn't be further cuts to departments. It would be the cuts that we made already, in that sense. That's number one. Number two, I agree that we do have to start putting money into surplus. I just don't agree that it should keep coming out of the taxpayers' money. I think that it should come out of, increased revenues and things like that when we get there. And, that's just me. And we have to change the way we're doing things. Like I keep saying, we have to change our government. We've all agreed on it. But this is honestly the only way we can force the hand. If we keep putting money there, then it's just our processes are just going to stay the same. It's never going to change. So, I mean, this is honestly the only way I feel like we can make those changes happen.
Kathleen?
I mean, surplus is the people's money. And
It
it's
is
like a
the
bank
people's
account that's there of the people's money.
Right, but they don't get to pick what...
You can't get it from...
But they don't get to pick what it's being spent on, right? In the middle of the year, that surplus can be spent on anything. We've seen it already. It's been spent on purchasing American Legion. It's been spent on purchasing Pocket Park. It's been spent on God knows what in certain instances that millions of dollars went to. I don't know. But the townspeople didn't vote on those things. It
They
just went.
voted for us to be here to do that.
Right. And they weren't happy with some of those purchases when I've spoken to them. So.
Paul, did you have your hand up?
No.
No? Alan? I just want to offer another definition of surplus. It is the people's money, but you accumulate some surplus, a prudent amount of surplus, so that if you have an emergency, you can make those repairs or deal with the emergency without going out and borrowing funds for that emergency. You have surplus to provide proper cash flow, so you don't have to borrow and pay additional interest just for the privilege of operating. You have surplus in some cases to earn a revenue item to offset taxes. So there are many reasons other than, to accumulate a prudent amount of surplus and to facilitate your operating. All right, thank you. Where are we going?
I'd like to make a motion that we drop it down to $95.
Well, you just can't make a motion to drop it down a particular number. You have to make a motion to
I did. I said...
call a special meeting, or go back into subcommittee, or identify cuts, or something. You just can't say, I want to drop it to $95. It's not an appropriate motion.
I thought by saying that, the money that we put in there, that we would cut back the money that we put back after the cuts.
That brings us, if I accept your numbers, and I do, that brings us back to 122.
No, 142 to minus $47. We're at 142 right now.
Alan?
Yeah, we're at 142.
Right.
The $200,000 that we put back into surplus in the revenues could be used towards a tax reduction. It'll give you about $50 of tax reduction if we push the surplus, for instance, from 425 up to 523. If we max out on our surplus again, and then I'd go back into the revenues that I had lowered a little bit, I would max them out to what we realized last year, and that's where you'd find the additional money you would need, about $200,000 total, to reduce the tax rate below $100.
Tom?
But if I understand what you're telling us, Alan, is that you don't consider that a fiscally wise thing to do, that your recommendation, 30 years of experience, an expert in municipal government, is that that would not be a wise thing for us to do, that could lead to us having to do emergency bonding, that this is not giving us enough cushion. Am I understanding you correctly?
Yes, I'm on the record as saying that.
Well, I'd have to say that I am not an expert in municipal government, and I would defer to you in this matter, and therefore I would not support Johnny's motion.
All right, well, there's a motion. Johnny can put it in the form of a motion to revisit the budget, to come up with additional mechanisms to reduce the anticipated tax increase to some level below $100 or something like that. There has to be a second. We have to see if there's any more discussion. We'll take a vote. If the vote passes, we'll schedule a budget meeting with the committees. I don't have a second.
Again, I understand the spirit of it, and I agree with the spirit of it. The practicality of it is, honestly, I'm afraid that the money's already spent on a tax appeal. That's really my concern. I think the money's already spent. And I understand it, and I hope this council is committed. If Alan gives me those, best practices checklist, that this council is committed to implementing those fiscal practices, so that we don't get into a situation where the surplus drops so low as it did, just because it was wiped out. I've heard so many excuses as to why the surplus should be used, or was used in the past. I heard it was the people's money. I heard another former councilwoman say that, well, the state wouldn't give us state aid if we didn't use the money, which I thought was honestly the most ludicrous thing I'd ever heard. That's like a millionaire saying, oh, I got to get rid of all my money so I can get welfare. It just didn't make any sense. And again, prior councils disregarded Alan's advice, and this council, once again, is confronted with making the tough choices that we've consistently made over the last couple of years. So I'm with Johnny in the spirit of it. I just think the money's already spent anyway, and we have to keep it in the budget.
All right.
So
I would like to say that I think the best practice idea for fiscal management is something that I would seriously consider being in support of, depending on the details. And I'd like to say that I think that's a good idea. Al?
Okay. Johnny's motion fails. I hear that there's potentially another motion to have Alan suggest a possible ordinance to make the council more fiscally prudent when it comes to the use of surplus. Is that a form of a motion?
I don't know if
Yeah.
I'll make the motion.
Well, could we add...
But I don't know that it needs a motion for Alan
No.
to provide us with a list of recommendations.
Get information first?
It's just to give the council to give Alan some direction. If he has a motion, then...
I would make that motion,
Direction.
Alan, most respectfully, that you provide us with that information.
I would expand it to include other fiscal controls also,
Yeah.
not just...
Absolutely.
Yeah.
So,
Yeah.
All right. Other practice. Is there a second?
Yeah, I'm going to second.
All right. All in favor?
Aye.
Any opposed, any abstained? Johnny?
Sorry, one more item for new business, and that's, I know we haven't met...
Did you vote on the last
Yeah.
thing? Did you vote on the fiscal?
I think I said aye.
Okay, good.
I know the subcommittee has not come down yet as far as this goes, but I wanted to get the process going so that the subcommittee can meet and vet the findings. So I'd like to go out to RFP for the recycling pickup, if possible. I know Alan got his hands on the bid spec from Ordell. I don't know if we got the one from Maywood back yet, but I would like to go to the RFP process and get some numbers back so that the subcommittee can meet and discuss our options.
Kathleen?
I went down and talked to John Lynch about the whole recycling issue. It seems that it's not almost worth it. Did he give you the numbers? Have you gone down there to speak to him?
I've spoken to him
And
several
he
times.
showed you all the different configurations?
He's been before us a few times with some of the numbers. I don't know if I saw the same numbers as you did, but we've never gotten outside numbers, so I don't know how you can make that.
Well, he can go down there and he'll tell you how we get paid for recycling and all this other stuff.
Have you seen the quotes from an outside vendor?
No, I haven't.
Then how can you make an informed
He has,
decision?
and he's told me that.
But we have to make an informed decision on our DPW.
I'll second Johnny's motion.
I think
to go out.
it's a prudent thing to
It's-
get numbers and...
It never hurts to get information. Just doesn't.
All right, there's a motion and a second. Any further discussion? All right, let's have a roll call.
Councilwoman Murphy?
Yes.
Councilman Quartz?
Yes.
Councilman Porco?
Yes.
Councilman McMillan?
Yes.
Councilman Bartolome?
Yes.
And Councilman Capoletti?
Yes.
All right, very good. Any other new business, unfinished business? No? Can, Alan?
One
Yeah,
question.
Ed.
I've been asked by a couple residents whether Mr. Enzimino might be available at another public meeting they weren't able to attend the first hearing, and they wanted to address them at a public meeting. So I was wondering if we can invite them up to the next meeting or the meeting after that.
All right, I have 1, 2, 3, 4 emails complaining of, not so much Mr. Anzavino's unavailability, but certainly the appraisal systems, unavailability, indicating that, the hearings were over, there's nothing more to do. So I'd say, sure, let's get Mr. Anzavino back here. All right? Made a note. Good. All right, can I have a motion to open the meeting to the public?
So moved.
Second.
All in favor?
Aye.
All right, this is the public's opportunity to...
You're the public.
Just if you want to speak and you want to just be heard, you could just stand up and give us your name and address. If you want to be heard and seen on YouTube, you can move forward to the microphone.
I just came to get information, that's all. My name's Chris Crassus, 240 Greenway Terrace. Obviously, I'm a River Edge resident of 18 years. I'm also involved in the development downtown, and I just came just to listen. I have my issues on my real estate taxes, and I just wanted to get information.
Okay.
We need...
Did you come and meet the guy from the appraisal company?
Yes.
Did he get back to you with any answers?
Yes. I got a slight reduction, but I'm probably one in the top 25 in the town who went out, and I'm really shocked and just devastated, actually. And I just wanted more information.
Did you get your property card? Did you go down there?
The property cards are in according to the tax assessor's office downstairs if you want to get it and check it to see if everything is accurate, that your square footage is accurate, that the number of bathrooms is accurate, those kind of things. Sometimes there are little discrepancies that, if you find any discrepancies, you may be entitled to an adjustment.
Yes.
Have you talked to Mr. Anzavino yet?
No, yet. I went through the process of American Appraisal,
Uh-huh.
and I did get a slight reduction. I clarified the entire rate card, and they were very responsive in 2 weeks. But it's just devastating.
All right, thank you.
Thank you.
Any council comments? Please, no. All right, good. All right, can I have a motion to adjourn?
Second.
All in favor?
Aye.
Any opposed, any abstained? All right, thank you very much.
Can we just beg?
Yeah.